pleased to change gears a little bit and talk about the relationship between differential privacy and privacy concepts from privacy law and policy. This work is an interdisciplinary collaboration involving computer scientists from the Center for Research on Computation and Society at Harvard and legal scholars from the Berkman Klein Center for Internet and Society. And this is all part of a broader effort called the Privacy Tools Project, and James gave an excellent overview of this project earlier. But that said, the opinions expressed in this presentation are my own. They're not those of the Berkman Klein Center, any of our funders, nor with the exception of co-authorship on previously published work, my collaborators. The motivation for this work is, as you all know, formal privacy models like differential privacy offer a solution for providing wide access to statistical information with guarantees that individual level information will not be leaked inadvertently or due to an attack. It's a formal mathematical privacy concept that addresses weaknesses of traditional schemes and more. And it's supported by a rich theoretical literature, and it's now in initial stages of implementation and testing by industry and statistical agencies. However, these tools cannot be used to share sensitive data with the general public unless they satisfy legal standards with some certainty. And I got the impression from the earlier talks today that maybe not everyone in the room is a privacy lawyer. So I'd like to give a brief introduction to privacy concepts from the law. Privacy is interpreted in a number of different ways. Alan Weston famously said that privacy is the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about them is communicated to others. But this is just one notion of privacy among many. Privacy is sometimes conceptualized as a function of generally accepted social norms. It's considered as access to information about this self, gradients between public and private information. Notions of individuality, personhood, intimacy, dignity, reputation, and autonomy often overlap with privacy. Privacy is sometimes considered the freedom to inquire. It's also considered an enabler of creativity or counterculture. And it's also conceptualized as control over information or power. And there are a number of different sources of governance of privacy. There's sources in constitutional law, which limit governmental action. So examples are the Fourth Amendment and the First Amendment. The first prohibits unreasonable search and seizure, and the second protects the first one here, the Fourth Amendment protects against unreasonable search and seizure, and the First Amendment, the second thing listed here, protects free expression and free association. Another source of governance is written law, including statutes and regulations. Examples include FERPA, which protects educational records, HIPAA, which protects medical records. There are human subjects research protection rules called the Common Rule. There are also various state laws, notably data breach notification laws at the state level. There's also common law, so this is judicially developed law, judicial opinions, ruling on the precedent of statutes. There's tort law and contractual law, all of which can be used to protect privacy. And privacy is relevant to data analysis and sharing. Various legal provisions restrict disclosures of identifiable information or sensitive information about individuals. An example of this is FERPA, which generally prohibits the disclosure of personally identifiable information from education records, except with consent or pursuant to one of several narrow exceptions to the consent requirement. For example, FERPA permits the disclosure of de-identified information. However, there's a lack of certainty around the use of terms like personally identifiable information and de-identified information, especially as the understanding of privacy risks continues to evolve over time. And this creates a number of challenges. De-identification standards are highly sector and context specific, and they vary widely depending on the setting. For example, some standards provide an objective for de-identification, while others prescribe a specific method for de-identification. And the applicability of these laws is typically a binary determination that turns on the interpretation of terminologies such as personal information, personally identifiable information, or individually identifiable information. And as a result, practices can vary. But generally, current practices are heuristic and focus on withholding, removing, or coarsening pieces of information considered to be identifying. And I'll talk a little bit about selected laws to give a sense of the many different types of legal requirements in place. Not able to cover everything, but I hope that this gives a sense of how these requirements can vary. I'll start with FERPA. This is the Family Educational Rights and Privacy Act. It protects personally identifiable information and education records maintained by educational agencies and institutions. And it explicitly protects personally identifiable information, which includes but is not limited to names, addresses, personal identifiers such as social security numbers, indirect identifiers such as date of birth, other information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with a reasonable certainty. And there's also one more category, information requested by a person who the educational agency or institution reasonably believes knows the identity of the student in the requested record. There's a lot to unpack here, and I'll discuss it later on in the presentation. But another important aspect of FERPA is that it permits the release of de-identified information without consent after the removal of all personally identifiable information, provided that the educational agency or institution or other party has made a reasonable determination that a student's identity is not personally identifiable, whether through single or multiple releases, and taking into account other reasonably available information. And it's important to note that once the information is de-identified, it falls outside of the scope of FERPA and can be used for any purpose. Another standard is found in the HIPAA privacy rule. HIPAA establishes rules governing protected health information held by covered entities like hospitals or health insurance companies. Protected health information is defined as information including demographic information, which relates to an individual's past, present, or future physical or mental health or condition, the provision of health care to the individual, or the past, present, or future payment for the provision of health care to the individual, and that identifies the individual or for which there's a reasonable basis to believe can be used to identify the individual. And HIPAA provides two methods for de-identification. The first is the expert determination method, which says that a person with appropriate knowledge of and experience with generally accepted statistical and scientific principles and methods for rendering information not individually identifiable, applying such principles and methods determines that the risk is very small that the information could be used alone or in combination with other reasonably available information by an anticipated recipient to identify an individual who is the subject of the information, and documents the methods and results of the analysis that justify such determination. And the second de-identification method is the safe harbor, which involves stripping the data of certain identifiers from a list of 18 identifiers. And the covered entity also must not have actual knowledge that the information could be used alone or in combination with other information to identify an individual who is the subject of the information. Another standard is found in the Privacy Act of 1974, which generally prohibits federal executive agencies from disclosing personal information about U.S. citizens and legal permanent residents maintained in a system of records, except as authorized by the data subject. And here, it protects specifically a system of records which contains information that is retrieved by an individual's name or other unique identifier. That's something unique to this law, that it only protects information held in a system of records where you can call up the record using the individual's name or other unique identifier. It's rather narrowly defined. The Privacy Act establishes a code of fair information practices that governs the collection, maintenance, use, and dissemination of information about individuals that's maintained in systems of records by federal agencies. This is the source of the FIPS, the Fair Information Practice Principles that you may be familiar with. There's also guidance from the Office of Management and Budget, which establishes breach notification policies and guidance for federal agencies, which has an interesting definition of PII. They say that the term PII refers to information that can be used to distinguish or trace an individual's identity, either alone or when combined with other information that is linked or linkable to a specific individual. Because there are many different types of information that can be used to distinguish or trace an individual's identity, the term PII is necessarily broad. To determine whether information is PII, the agency shall perform an assessment of the specific risk that an individual can be identified using the information with other information that is linked or linkable to the individual. In performing this assessment, it is important to recognize that information that is not PII can become PII whenever additional information becomes available in any medium or from any source that would make it possible to identify an individual. And this definition stands out because it requires anticipating future changes that would make non-PII become PII. Another standard is found in Title 13, which authorizes the U.S. Census Bureau to conduct the census and supplemental surveys. It provides that the information collected by the Census Bureau from individual persons, households, or establishments be kept strictly confidential and be used only for statistical purposes. Title 13 prohibits Census Bureau employees from making any publication whereby the data furnished by any particular establishment or individual under this title can be identified. And this is interesting because Title 13 protects information furnished by a particular establishment or individual to the Census Bureau, and this is interpreted quite broadly. There's even a Supreme Court case that says that this protects information about the vacancies in a neighborhood. So, which homes are vacant is considered information that's furnished by individuals, such as the neighbors to those houses. So that's something that might not traditionally be considered PII, but it's something that the Census Bureau has to protect under Title 13. The next law is CIPSEA, the Confidential Information Protection and Statistical Efficiency Act. It protects information collected by any federal agency directly from respondents under a pledge of confidentiality for exclusively statistical purposes. It protects data in identifiable form, which is defined as any representation of information that permits the identity of the respondent to whom the information applies to be reasonably inferred by either direct or indirect means. And this definition is interesting because it's talking about inference and the level of uncertainty in identifying a person that would be permissible. And finally, there's state data security laws, including the one here from Massachusetts, which protects personal information defined as the combination of a Massachusetts resident's first name or first initial and last name, and any one or more of the following: social security number, driver's license number, or state-issued ID number, or financial account number, or credit or debit card number. And this definition explicitly excludes publicly available information. But this definition is somewhat narrower than some of the others. If you remove these pieces of information, the law does not apply. There are a number of gaps between differential privacy and these legal standards of privacy, which create challenges for formal privacy models. Demonstrating that formal privacy models satisfy the applicable legal requirements is challenging due to conceptual gaps between the legal and technical approaches to defining privacy. In particular, information privacy laws are generally context-specific, subject to interpretation. They allow for some degree of flexibility in interpretation, and they rely on traditional, often heuristic conceptions of privacy, and this creates uncertainty for the implementation of more formal approaches. And as an example, can talk about some of the points of mismatch between FERPA and differential privacy. FERPA applies to highly sector and context-specific settings. Certain pieces of information about students within a school are protected. And you can imagine if you have a data set with data from multiple sources, you might have to protect information about students one way and information about medical patients in a different way. And so that this sectoral approach can create challenges, whereas differential privacy offers this general privacy protection in contrast. FERPA seems to contemplate a small set of specific types of privacy attacks. In the guidance on FERPA, they seem to be referring to record linkage attacks, but they don't provide much guidance on how to think about other types of inferential attacks, whereas differential privacy addresses a very large class of potential data misuses. FERPA protects a small set of information defined as non-directory, personally identifiable information, whereas differential privacy protects any information contributed by an individual. The guidance on FERPA seems to refer to obvious extreme cases, not to more difficult gray areas. So in discussing the risks in releasing aggregate data, say a contingency table, they say that you can't release a table where one of the cell values is 1 or 2, relating to 1 or 2 people. But it doesn't give you enough guidance to make decisions with respect to more difficult types of considerations when it comes to privacy. Whereas differential privacy applies to all analyses and does not leave these sorts of gray areas. FERPA, in the guidance, it refers to releases of microdata and certain types of tabulations, but it's not clear how it applies to the releases of a statistical model or machine learning analysis. And FERPA is arguably not rigorous or formal from a technical standpoint, which makes it difficult to reason about a mathematically rigorous definition like differential privacy. So is it possible to bridge between these very different languages, the language from law compared to the language mathematics? We have 2 potential approaches that seem promising. This is preliminary work, but I'm excited to share some sketches of these ideas. The first one is a formal modeling approach. The idea is to be able to rigorously argue that a technological privacy solution satisfies the requirements of a particular law. The proposed approach has 2 components. The first is the extraction of a formal mathematical requirement of privacy based on a legal standard found in an information privacy law, and the construction of a rigorous mathematical proof for establishing that a technological privacy solution satisfies the mathematical requirement derived from the law. And we illustrate this by formally modeling FERPA, and this is described in a forthcoming law review article. What we aim to do is extract a formal model of the Department of Education's privacy desiderata for FERPA in the form of a game-based privacy definition. We aim to provide a concise and fairly intuitive abstraction of the requirements of FERPA. And this will enable us to prove that if a formal model, such as differential privacy, satisfies the game-based definition we've extracted, then we have a strong argument that it satisfies the requirements of FERPA. And although FERPA is not written with such a game framework in mind, we can claim and demonstrate that it's possible to extract a game that is based on its requirements. But first, a little bit more background on FERPA. FERPA allows the release of directory information. So this is information that can be made public because it's not considered to be harmful. So this is information like names, degrees, extracurricular activities, things you might find in a school yearbook. So this is the provision that allows yearbooks to be released. And it also allows the release of de-identified information. And de-identification can be thought in terms of a computation. For example, it requires the removal of identifying attributes. This can be seen as a computation to redact those identifiers from the input data. And framing it in this way is useful for modeling a law's requirements using more formal language. And this modeling allows us to extract a mathematical definition for determining whether a particular computation meets the FERPA privacy standard. And this is a simplified version of a FERPA privacy game. And the paper goes into this in much more detail and much more precision. But the general idea is you have the mechanics of the game, which pass directory information to a potential adversary. And it passes the directory information as well as non-directory personally identifiable information to the computation. The computation returns this computation result, which is passed on to the adversary. And using the directory information and the result of the computation, the adversary makes a guess of the private information. The adversary wins if the guess of the private information equals the private information. And I can talk a little bit more about how we developed this model. One of the things that we have to model is what is directory information. The regulatory language is ambiguous, and this is because each school is given a lot of discretion in designating information as directory information. So how different schools interpret this can vary widely and is likely to continue to evolve over time. So we interpret the language as conservatively as reasonably possible. In other words, where there's an ambiguity, we err on the side that's most beneficial for the adversary. We could make assumptions in defining directory information in our model. However, new interpretations could call these assumptions into question. So instead, we let the attacker choose what constitutes directory information. We also model the adversary, and we do this by relying on the definition of personally identifiable information in FERPA. If you recall from earlier, personally identifiable information is information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. And the highlighted language there is what we take as FERPA's implicit adversary. And interpreting that language, we found a few key points from the guidance from the Department of Education. We know that we should not assume anything about the skill level of the adversary. So by referring to a reasonable person in the school community, the Department of Education says they don't mean someone who lacks technical skill in re-identification. So we don't assume that the adversary doesn't have that. The standard is also based on the knowledge of a member of the school community, which the Department of Education says is meant to mean that the potential adversary has potentially a lot of personal knowledge about schools, about students in the school community. So it refers both to the knowledge of a member of the community as well as the knowledge that any person might have. So this is meant to be a stronger standard. The adversary can have both high-level knowledge, such as knowledge about the demographics of the school, as well as insider knowledge about specific individuals in the local community. So what we take from this is that the adversary clearly has potentially a lot of knowledge, but by definition does not have personal knowledge of the relevant circumstances. In our model, this means the adversary has access to any information that's publicly available, but has some uncertainty about private student information. And we can model this knowledge using probability distributions. The adversary associates with each student a probability distribution that represents her knowledge about the private information of that student. And we allow the adversary to choose these statistics, thereby strengthening the model. For example, if Alice comes from a school where 50% of the students fail the state math proficiency exam, then the adversary might associate with Alice a distribution that has her failing the exam with a probability of 0.5. For the full proof, I would refer you to the paper, but the takeaway here is that developing a formal definition of privacy protection based on the requirements of FERPA allows us to reason with high confidence about whether the use of a privacy technology satisfies FERPA. We can prove mathematically that any computation that is differentially private meets this definition. And since the requirements of this definition are likely stricter than that of FERPA, it satisfies the privacy requirements of FERPA. And then this, yes?
Can I ask a question?
Yes.
Yeah. Is it possible to, are there significantly weaker things than differential privacy that also basically meet the criteria of the model you guys, the formal model you guys extracted?
It's a good question. We didn't explore that explicitly. We left that as a question for future researchers, both to see whether a new model could be extracted from FERPA, which other techniques could be shown to satisfy, or to show that other techniques do satisfy the model that we extracted.
Right. I was asking the simpler question, I think, which is
yes.
Just a very quick follow-up to that. Can you show that that the definition you get is meaningful? And in other words, that the attacker can't just compute the original database from whatever you gave him, even using all these techniques?
That's a good question. It might be too technical for me.
Okay.
I don't know if any of the co-authors have any thoughts on that.
I'll have to refresh my memory. We can discuss that later, I think.
Okay. So the second approach we explore involves interpreting the differential privacy guarantee in different ways. Legal requirements relevant to issues of privacy and computation rely on an understanding of a range of different privacy concepts, as I gave an overview of before. While none of the privacy concepts that appear in the law refer directly to differential privacy, the differential privacy guarantee can be interpreted to in reference to these concepts, while accommodating differences in how the concepts are defined across different contexts. Some of the common privacy concepts that appear in the law include personally identifiable information, de-identification, linkage, inference, identification risk, consent and opting out, and purpose and access restrictions. These concepts are interpreted differently across laws. They also appear in the technical literature, often with different definitions and interpretations. For example, personally identifiable information, sometimes referred to as personal information or individually identifiable information, is a central concept appearing in information privacy law. Legal protections typically extend only to PII, and information not considered personally identifiable information is not protected. Examples include FERPA, the HIPAA privacy rule, the Massachusetts Data Security Regulation, the OMB definition of PII, among many others. Although definitions of PII vary significantly, they're generally understood to refer to the presence of pieces of information that are linkable to the identity of an individual or to an individual's personal attributes. However, the term PII does not have a precise technical meaning. In practice, it can be difficult to determine whether information is personal, identifying, or likely to be considered identifying in the future. Further, the meaning of PII in releases that are not in a microdata or tabular format, such as statistical models or outputs of a machine learning system, is unclear. But regardless of the definition of PII that is used, we argue that differential privacy can be interpreted as essentially ensuring that using an individual's data will not reveal any PII that's specific to her. And here, the use of the term specific is used to refer to information that cannot be inferred unless the individual's information is used in the analysis. Moving next to de-identification. This term refers to a collection of techniques that aims to transform identifiable information into non-identifiable information while also preserving some utility of the data. In principle, it's intended that de-identification, if performed successfully, can be used as a tool for removing PII or transforming PII into non-PII. Examples include FERPA and the HIPAA privacy rule, which explicitly refer to de-identification. Any algorithm that satisfies the requirements of differential privacy has the property that using an individual's data will essentially not reveal PII that's specific to him or her. And based on this, you can argue that because the output of a differentially private computation does not reveal such information, any differentially private algorithm should be considered sufficient for de-identification. The next term is linkage. One of the most common modes of privacy loss recognized by privacy regulations implicitly or explicitly is a successful record linkage. This term typically refers to the matching of information in a database to a specific individual, often by leveraging auxiliary sources of information. An example is FERPA, which defines PII in terms of information linked or linkable to a specific student. Linkage attacks have a concrete meaning, as far as we can tell, when data is published as a collection of individual level records, often referred to as microdata. However, what is considered a successful linkage when a publication is made in other formats, such as statistical models or synthetic data, is open to interpretation. Yet, despite these gaps, we can argue that differential privacy addresses reasonable interpretations of record linkage, regardless of the definition that you use. And there are three alternatives here. The first is that you can argue that microdata or contingency tables that allow the identification of population uniques cannot be created using statistics produced by a differentially private tool. The second argument is that differential privacy masks the contribution of a single individual, making it impossible to infer any information specific to an individual, including whether an individual's information was used at all. And finally, differentially private statistics provably hide the influence of every individual and even groups of individuals, providing protection not only against releasing exact records, but also proximate statistics that could leak individual level information. Any one of these arguments could be used to say that differential privacy addresses record linkage. The next term is inference. Some information privacy laws or interpretations of these laws refer to modes of privacy loss involving inference, either explicitly or implicitly. One example is CIPSEA, which you might recall protects any information, any representation of information that permits the identity of the respondent to whom the information applies to be reasonably inferred by either direct or indirect means. There also seems to be some conception of this in other laws where they refer to reasonable certainty. So FERPA, for example, defines personally identifiable information in part in terms of information that would allow one to identify a student with a reasonable certainty. In interpreting this language, it's important to distinguish between two different types of inference. Inferences about individuals and inferences about large groups of individuals. This is key to enabling socially beneficial uses of data, such as research investigating the relationship between smoking and lung cancer, while protecting individuals from disclosures of information specific to them. You can argue that differential privacy rules out inferences about individuals, thereby protecting individuals from inferences about values or attributes that are specific to them. To achieve this goal, differential privacy adds a small amount of uncertainty, similar to traditional SDL, statistical disclosure limitation techniques, but doesn't protect against the latter type of inferences, those about large groups of individuals. The next concept is identification risk. Some information privacy laws refer to an acceptable level of risk of identification of a record in a data release. Other laws acknowledge implicitly or explicitly that any disclosure of information carries privacy risks, and therefore the goal is to minimize rather than eliminate such risks. For example, the Department of Education has released guidance referring to the goal of FERPA's de-identification requirements in terms of minimizing the risk of disclosing PII in redacted records or statistical information. And the HIPAA privacy rule explicitly requires covered entities to use de-identification techniques prior to releasing data in order to create a data set with only a very small risk of identification. And as you know, differential privacy enables a formal quantification of risk. And the privacy loss parameter can be tuned to different legal requirements for minimizing risk. And regardless of how identification risk or privacy risk more generally is defined, differential privacy guarantees that the risk to an individual is almost the same with or without her participation in the data set. In this way, differential privacy can be interpreted to guarantee that the risk to an individual is minimal or very small. The next two concepts are consent and opt-out. Some privacy laws include consent provisions or opt-out provisions by which individuals can choose to allow or not to allow their information to be used by or redisclosed to a third party, respectively. For example, FERPA, the HIPAA Privacy Rule, and the Privacy Act generally prohibit the disclosure of certain records containing personal information, absent the consent of the individuals involved. FERPA also includes a provision requiring educational agencies and institutions to offer students an opportunity to opt out of the disclosure of their personal information in school directories. Differential privacy can be viewed as automatically providing all individuals in the data with the protection that opting out is intended to provide. When differential privacy is used, the consequences for an individual's privacy are almost the same whether or not an individual's information is included in an analysis. And differential privacy provides all individuals with this privacy guarantee, thereby avoiding the possibility that individuals who choose to opt out would, by doing so, inadvertently reveal a sensitive attribute about themselves or attract attention as individuals who are potentially hiding sensitive facts about themselves by opting out. The final concept is purpose. Information privacy laws often permit the non-consensual disclosure of data for certain purposes, such as statistical purposes. Examples include Title 13, which restricts the use of confidential information from respondents, prohibiting uses for any purpose other than the statistical purposes for which it is supplied, and CIPSEA, which states that data or information acquired by an agency under a pledge of confidentiality and for exclusively statistical purposes shall be used by officers, employees, or agents of the agency exclusively for statistical purposes. And CIPSEA defines statistical purpose as the description, estimation, or analysis of the characteristics of groups without identifying the individuals or organizations that comprise such groups, and includes the development, implementation, or maintenance of methods, technical or administrative procedures, or information resources that support the purposes described. Legal requirements reflecting purpose restrictions can be divided into two categories. Restrictions limiting use to statistical purposes, including statistical purposes involving population level rather than individual level analyses or statistical computations, are consistent with the use of differential privacy. Tools that satisfy differential privacy can be understood to restrict uses to only those that are used for statistical purposes. Other use and access restrictions that you might find under other laws, such as FERPA, which allows information to be shared with certain people who have legitimate educational interests and will use the data to fulfill those interests, may be orthogonal to differential privacy. One other interesting note is that public data releases that are free from use restrictions may even be viewed as demanding the use of formal approaches such as differential privacy that preserve privacy in post-processing because it can enforce sorts of purpose restrictions that the data holders may want to enforce automatically. With the emergence of new technologies based on formal privacy models, can we claim they satisfy existing regulatory requirements? We argue that while it's challenging due to conceptual gaps between formal privacy models and concepts used in law and policy, there are at least two promising approaches to this problem. And you'll recall that the first one involved extracting a formal conservative model of the regulation to make a combined mathematical legal claim that differential privacy satisfies a legal requirement. And the second involves interpreting the differential privacy guarantee in terms of the specific language of a relevant law or policy in order to argue that the use of differential privacy is sufficient to satisfy requirements such as protecting PII from disclosure. We have two papers based on this work that are forthcoming. Encourage you to look at our website if you're interested in learning more. And I'm happy to take any questions. Chris?
Oh, yeah. Question, getting back to the record linkage, and how would the law look at an unsuccessful or an incorrect record linkage? So just as an example, an obviously extreme and completely foolish thing to do. Suppose we took a record that was about Alexandra Wood and removed your name and your ID number and put instead my name and my ID number. Now, on the one hand, the way linkage is defined, that's not a record about me, it's a record about you. And someone who tries to link it is not going to link it to you. So that would seem an unsuccessful record linkage. You're not being able to link the record. On the other hand, from my point of view, it's a pretty scary thing. Even though, how does that sort of issue come? How does that fit within the law?
Can you clarify the example? Why is that not a record linkage?
Because it's your record and it's linking me to your record. That's not linking the person to their record.
Like your college transcript with Chris's name on it.
Yeah, it's not the record is about an individual, you, and an adversary is not able to successfully link you to the record. But they are, but when they try to do record linkage, they end up getting it wrong.
Mm-hmm.
But perhaps believing quite fully that they're correct, even though they did get it wrong.
Mm-hmm.
What's the legal view of that? Is that a problem, or is that, is there any view of that? If more generally, if an adversary gets hold of the data, tries to infer something about an individual, and then makes a claim that's an incorrect claim, is this viewed as a privacy violation? If they made a correct claim, then yes, I would say it would be viewed typically as a privacy violation. But if the claim they make is incorrect,
Well, wouldn't it depend on the probability of them being correct? Because, for example,
Does it?
I could just take the directory information and randomly assign names to records, and that shouldn't be a problem.
Right, so FERPA says that you shouldn't be able to link the records with reasonable certainty. So it would come down to, whether you could reasonably make that linkage, not whether you actually did.
So I guess, sorry, maybe one just directly related to this. One issue is if the law sort of, this legal view of things incorporates, Kirchhoff's principle, for lack of a better name, the idea that the algorithm itself should be kind of, one should assume that an outside attacker knows the process that's being used to sanitize or otherwise, treat the data before publication.
So,
Well, that was a law question about the law, which I can't answer. But I was going to say, so I don't know whether there's any occurrence of Kirchhoff's principle in the law. I know we talk about it in the primer paper.
if only, that would make things a lot easier.
But the other thing I was saying is following on the same discussion. In essence, I think one way to encapsulate the arguments that Alex was outlining with the second type, not the formal modeling, is first you make an argument that in what one might call the privacy ideal model, that is, if your data is removed from the data set, then to make an argument that almost by definition, linkage and all of these other things are impossible in that setting. Now, the example that you pointed out is that a false linkage is possible even if your data wasn't in the data set, because, and so I think that's the discrepancy, perhaps. So if you can't make the argument that with your data removed, if your data wasn't in the data set, that if an attack on your privacy is still possible, then I think most of the arguments that we're trying to make here would fail already at that point.
Can I ask sort of a rephrasing maybe of how I interpreted Chris's question, which is, can you say how all of these laws might interact with, say, libel law? Or, because so far we've talked about privacy, but not the degradation of accuracy. And so what if the release of this data set makes it more likely for people to believe in false things? Could you be held, is there any sort of connection there? That I release a data set that makes you more likely to believe in something false about some other person?
It's a good question. Some of the laws, such as Title 13, refer explicitly to the accuracy of the information and the need to release accurate statistics. So I could see that question coming into play in that context. But there hasn't been much discussion of that problem in the literature.
So I have a comment here. I think even without privacy, that's an interesting question, because data already has errors. And what you release could be completely wrong because of the way the errors you had in collecting the data, in matching the data, integrating the data across systems, and so on. So I think in general, what data would be to just say this is our best effort, and beyond that, really, you can't give any guarantee.
Well, but there are certain sources of data for which it's known that the owner has perfect information, right? Like if we're talking about transcripts from universities, the assumption is that their underlying data set is very clean. And so then introducing some uncertainty into that information to protect privacy, but if it causes false correlations, does that lead to problems when people had the assumption that it was the true data owner with perfectly accurate data? Otherwise, I agree with your statement. But, and I agree it's like an issue that exists also in the time of privacy. But anyway, sorry.
Adam.
So, sure, take the discussion in a slightly different direction. Okay, so you mentioned several times that there's a gap in the types of specifications that go into a law or even a regulation and or a legal opinion, judicial opinion versus what we write in technical papers. And I guess the sort of two questions that go with this is, one, is this a desirable feature to have the laws not be written as technical definitions? And secondly, well, yeah, and you could sort of ask the same question for other regulations or opinions. And then also, what kind of guidance does this, the flip side of that question, which is sort of what kind of guidance does this analysis give to how regulations should be written or bills, both, again, but at each of these levels, how the kind of legal analyses or laws or regulations should actually be phrased.
Mm-hmm. Yeah, excellent questions. I think that this can help point to ways that laws could be rewritten in the future. I think that by showing that differential privacy and how it should be treated under the law is uncertain, can help show how the law could be written with more general definitions that don't rely on things like identification or de-identification, that can establish a more general privacy goal that lots of different techniques could be shown to satisfy, including techniques that aren't traditional de-identification techniques. A number of the insights from the differential privacy literature can also help inform new privacy regulations that are stronger, that incorporate notions of composition and privacy budget and things like that, which I don't think that the law needs to be written to say you need a privacy budget, but I think acknowledging or recognizing that there is a privacy budget can help inform how new laws could be developed.
There seems to be a real aversion in the legal community to putting, to having sort of really precise technical statements, and some of that I think is sort of for good reasons, in the sense you don't want to overspecify, like a law shouldn't overspecify its implementation, right? And other, just to refer to a story that was in the news this week, part of it seems to be just aversion to math, from like our Chief Justice, for example. And so I don't know, I guess I was just, I'm curious what, what role should sort of like, at what level should what level of precision should match to the different, levels at which laws and regulations are written?
It's a very good question. I think there's a lot of value in flexibility, in broad general definitions that can be interpreted in different ways, especially as new technologies will emerge and need to be shown to satisfy these definitions. So it's important to have something general. And I think the emergence of differential privacy has shown how the current privacy definitions in the law, which were thought to be general, actually aren't, and need to be rewritten or reinterpreted so that new technologies that emerge can be shown to satisfy them.
It's lawsuit, who's liable? Is it the person who ran the program or the person who wrote the program?
The answer is it varies. It's often, under most of these laws, it would be the data holder, the person who's responsible for protecting the information. They would be the ones held liable if there were to be a breach. So in the context of FERPA, it would be the school, not the contractor to the school that developed the algorithm. Yes?
So I'm a researcher, and under the federal grant, I have collected data. And that same federal grant requires me that within a certain period of time, I actually deposit their data into their repository, for which others can use the data. And so far, let's say with the health data, they further say, well, and you need to make sure that these data are de-identified and disclosure risk is minimized before you, or something has been done with it before you submit it to our repository, et cetera, without giving specific details. So at that point, who's the owner really? Who handles the data? Whose responsibility is it? Right? You know what I'm asking? There are a couple of steps here, right?
Mm-hmm.
So I collected the data. By law, I'm required now to submit the data to NIH, to their genomic gap, what is it called? I forgot, sorry. One of their databases.
DBGAP.
DBGAP.
The repository, sorry?
DBGAP?
Yes, thank you, DBGAP, that's the word I'm looking at, just for a specific example, right? And they told me that when I collected the data, I'm responsible for de-identifying and handling any potential disclosures. Now I submit those data, potentially stripped or handled or edited, to the DBGAP.
Mm-hmm.
And now DBGAP, others will use the data from the DBGAP. And let's say something happens. Who's responsible? Does it go back to me who collected the data and originally had to handle the privacy? Or does it go now back to DBGAP, or that is the NCHS or NIH, whichever level you want to consider here?
It depends on a number of factors, including which laws apply, what the contractual arrangements are. So, as you're transferring the data, you might require the recipient to indemnify you. So if something goes wrong, they'll be responsible and they'll cover the costs. And so it's so specific to the particular context, it's hard to say in the abstract.
Do you know, is this clear? Is it clearly specified anywhere? Because
In the contracts, it would be clearly specified.
One hopes.
You probably clicked I agree when you uploaded the data.
Forget about reading 10 pages that I'm supposed to read, right? I think I bring this up because I think this is important
Clearly
for
laid
researchers.
out
This is
on
a real
page
problem,
13 of
so.
the ULAB.